Hello, everyone. We are live. This is our first live. Please comment in the chat and let me know that you are here. If you see me looking down, I'm looking down at my laptop. See if you guys can see me. I'm going to share it on all of my respective platforms and turn off my cell phones. Turn on Do Not Disturb as well. Please comment and let me know that you can, in fact, see me. Hi, Ari. I can see you. See if I'm going live on YouTube. Okay. It says I'm live. So let me share this on Facebook. Forgive me, y'all. It's been a minute since I've been live. All right. So let's get started. I'm going to share my screen so that you guys can see it. One second, guys. Having some technical difficulties. Hi, Ari. I can see you. But I don't think anyone else can see you. Okay. Ari. Oh, Ari. I see. The morning shenanigans. Okay. It's been a long morning, so my hair is on top of my head. Okay. All righty. So, welcome to the Founders Formula, guys. Forgive me, my admin is sending me messages and they know that I'm live. Okay. Welcome to the Founders Formula. Today, I wanted to hop on and have a monthly live session with all of my fellow entrepreneurs. This is an opportunity for you to pick my brain and also hear a discussion on a topic that I've chosen for the month. So, today we're going to discuss contracts, but before we delve into contracts, I want to tell you a little bit about myself. Hello, everyone. My name is Shawnette Stokes. I am the managing attorney at Stokes Law Group, where we specialize in estate planning, probate, trademarks, business law, personal injury, and civil litigation. Who are we? We are a law firm that specializes in protecting and creating wealth for entrepreneurs, business owners, and executives. So today's agenda is our introduction, which we just did, topic of the month, a Q&A session, a pop culture topic if we have time, networking, upcoming events, resource sharing, any special offers that we have, results that you all want to share, conclusions, and my thank yous. So, what is Founders Formula? Founders Formula is first, it is actually a workshop where it's a go at your own pace workshop for all new and budding entrepreneurs that want to learn about estate planning and business. Which business structure should you choose? Copyrights and trademarks, and learning the difference between the two of those intellectual properties. So, what is the Power Hour? The Power Hour is a monthly networking opportunity for us to, one, discuss the topic of the month, and two, network. We want to be able to build relationships during this hour and also share resources that we have used and we know that are tried and true. So, let's delve into the topic of the month. I have been reading a lot of contracts in the last few months, and I have seen so many mistakes pop up while I'm reading these contracts, and I wanted to share them with you. So, with mistake number one for contract drafting and review, I find it that most entrepreneurs do not get an attorney to review their contracts. They just simply sign it. They're excited about the opportunity and they just want to move forward with the transaction without actually knowing what their legal obligations are. So I always recommend that my entrepreneurs, first and foremost, please, at the very least, get an attorney to review your contracts. Attorneys some attorneys will charge you at the hourly rate, some will charge you at a flat fee. With my firm, we charge at a flat fee and it's per page. So I recommend that when you are dealing with an attorney, you want to make sure that they fit your budget and that there's no surprise costs at the end. So I would always recommend that you contact an attorney that follows a flat fee rate when it comes to reviewing contracts. The second mistake that I often see with entrepreneurs is that they're not even reading their own contracts. I know it's insane. Most of us will probably read the first two pages and all of the clauses that make sense to you. But in reality, every clause is applicable to you, especially if you're signing the contract. So I would recommend when you get a contract, Read it from top to bottom and even redline that contract. And what does that even mean? Get a red pen and cross out clauses that you don't agree with. That is when you take it to your attorney and have your attorney review it for one, comprehension and understanding, because there are some things that you truly don't know what certain clauses mean. And two, the attorney can tell you that this clause means this in this particular instance. I always tell my clients, and I'm always the bearer of bad news. Well, what if this happens? What if this happens? You always want to have contingencies in place in your contract specifically to make sure that if something happens that neither one of you anticipated, there is a clause that is in place to protect the transaction. So, say for instance, if someone fails to pay on time, there's a clause that dictates late payments. If a party wants to cancel the transaction, there should be a clause in there that terminates the transaction. Okay. So, mistake number three. This is a huge mistake that I find is missing in a lot of contracts. There's no attorney's fees clause in these contracts that I'm reviewing. And I know that we enter into contracts with the hopes that the person is not going to breach the contract. Of course, we want to make sure that, the transaction that we're entering into is ideal for all parties. But what happens in the event that you have to sue that person for non-performance? And when I say non-performance, it could be the actual non-performance of payment or non-performance of the act that they were supposed to engage in to facilitate that transaction. And when you find that that person did not perform or uphold their side of the bargain, then you have to take them to court. Who is going to pay your attorney's fees? Most causes of action, say a contract breach, for instance, there's no built-in statute that says if I have to take you to court, I get my money back. But your contract can say that. Your contract can dictate if you are the prevailing party, or even if you have to take the person to court, you are entitled to your attorney's fees. And this can be put in contract. And if both parties sign it, then it is a binding contract. And remember, if you get a contract that says that if I have to take you to court, you have to pay my attorney's fees, you better believe that you should be redlining that contract, because it should state the prevailing party is entitled to their attorney's fees. But most contracts are generally drafted in the favor of the person that drafted the contract. So it is your responsibility to make the contract balance. And that's why I said get a red pen, mark through it, and make sure that you negotiate that contract. So I'm going to give some opportunity for questions. I've gone over two mistakes and we have a few people in here. Do we have any questions from the audience? Okay, so no questions. The next mistake is not the next mistake I see happening is not putting intellectual property ownership in the contract. So when you're dealing with third parties and if they're creating content for you, if there's some kind of work that they're doing that is producing a tangible thing, you want to make sure that there is a clause in your contract that says that you are the true owner. Because in copyright law, and most often in any intellectual property laws, the person that created the work is the actual person that owns it. unless it's a work for hire. And with copyrights, work for hire agreements need to be in writing, and you need to be able to produce it to show that to the copyright office that while you did not create the content, you surely did hire someone, and that person created that content at your direction. So I would always recommend having a clause in your contract that speaks to who owns the intellectual property. And the final mistake I've seen is failing to have definite terms in your contract. So, for instance, if someone breaches your contract and there is no termination clause that says that in the event of a breach, we are to terminate this contract and you are to return all of our documents in a specified time. Or there is a clause that, for instance, the person fails to pay you on time. Having a payment term in there that says, if you fail to pay on time, here is the consequence of that late payment. So that could be an interest or a flat fee that you require them to pay so that they can recoup your expenses for having to go after that payment. So those are the 5 contract mistakes that I have found and I've seen. There's a lot more that I've uncovered, but those are the major mistakes that most entrepreneurs are overlooking when it comes to drafting and reviewing contracts. So, to reiterate, read all of your contracts, have an attorney review it. Do not just go to your attorney and said, "I have no idea what this contract says, but I need you to look it over for me." Also, make sure that you have an attorney's fees clause in that contract and be sure that it is balanced. Make sure that it doesn't just say that if the person has to take you to court, that you have to pay their attorney's fees. Make sure that it speaks to a fair consequence of having to go to court. So the prevailing party must receive their attorney's fees as a result of having to take you to court. And then also be sure to put intellectual property language in your contracts. And finally, be definite in your terms. Have a term that says, hey, if you do not pay me on time, this is the consequence of failing to pay. And also have a term for termination and returning your intellectual property. All right. Any questions, guys? Now is the time to ask them. Daryl, do you have any questions? You can send the message. If you don't want to hop online or if you don't want to hop on camera, you guys can send a message via the chat. They're typing up the messages right now. I hope. I'm waiting. Questions? Don't all ask at once, guys. Oh, I was looking at the wrong chat. That's why I couldn't see the questions. So, okay. Daryl has no questions. All right, guys. Well, let's talk about upcoming events that we have. All right. So, oh, we do have a question. Let me bring that to. See if I can post that question. Okay, the question is, if I'm drafting a contract, should I let me put it in uh, PG format. If I'm drafting a contract, should I just write it, or is there a place where we should get templates or something? Oh, well, one of the uh, mistakes I wanted to add was getting your contracts off of Google. That is one thing that I find happens a lot, is that more often than not, our clients will get a contract off of Google and they will subject themselves to a jurisdiction that they don't even live in. I had a situation where I had a client that got a contract off Google and I reviewed it. And thankfully, she did have me review it. But prior to me receiving it, she was going to go to court in California. So just be mindful when you're reviewing contracts that are off of the internet, they're not one size fits all. That means that while it may have worked for that person, it may not work for you. So, at the very least, yes, you can get your contracts off Google, but get an attorney to review it and let that be the foundation of that contract, but not the final destination of the contract. So, thank you so much for that question. So, we have an event coming up on Saturday, which is August 19th at noon. I will be speaking on contracts, copyrights, and royalties. And we're going to talk more about contracts, the requirement for contracts, in addition to how can you get royalties as a self-published author. I hope that you all can join me. We will have some recordings from that event, but I don't want to record the entire event because this is unfortunately not my event and you all should buy a ticket. Any more questions? Maybe a recommendation or anything. The question is maybe a recommendation. As I said, with a recommendation for contracts, I would say try to steer far away from Google, but hire an attorney because attorneys have built their own law library, and the contracts in their library will more than likely benefit you far more than Google can. You guys can still send me questions. I will answer them as we progress through the slides. Okay, so another event is next Thursday, the 24th. That is supposed to say the 24th at 6 p.m. It is the Foundations of Wealth workshop, financial literacy and estate planning. And this is a local workshop where we will speak on estate planning and life insurance. And that is next Thursday. And we will be serving food, and it's a free, zero cost event for you. Any more questions, guys, as we go through? Okay, securing your tomorrow, the Legacy Lounge. We will be conducting a wills workshop. And what does that even mean? We're actually going to go into the community and draft free wills for our community. And it's going to be myself and another attorney, Latera Scherer. And we will tag team drafting wills and have a final will signing ceremony at the end. And that's going to be tentatively in October. All right. Any questions, guys? If there's no questions, then I guess we can wrap this up. Daryl, Ari, how can we sign up for the living will thing? Okay, great question. Uh-oh, I did not mean to put that. Okay, so how do we sign up for the will thing? So you can sign up on Eventbrite. We will send all of the attendees today an Eventbrite link so that you can sign up. And just remember, these estate plans are going to be, there's no trust involved. So you want to make sure that you qualify. So we will send out all of the qualification information first, and you will sign up and apply, and then we will determine whether or not you are eligible to receive the free estate planning. Any additional questions before I let you all go? All righty, guys. Well, thank you so much for joining us at the Power Hour. We're going to do this every month. So every third Tuesday of the month, you will see me on live at 12:30. And I hope to see you again next month. Have a wonderful day, guys. Bye.